I'm not sure who has an opening statement and who doesn't. We haven't been submitted anything. Mr. Kadzik, do you have any open comments?
No, I do not have an opening statement, Mr. Chairman, but I would note for the record that I was not compelled to be here today. I came here voluntarily.
Let the record reflect that none of them ultimately accepted service in terms of accepting the subpoena. I'm just saying in general, it did require us to get to the point where I signed subpoenas and presented those subpoenas, but all of the witnesses here today ultimately came here voluntarily. And I appreciate you highlighting that.
I'm not sure who those subpoenas were produced to, but they were.
And Mr. Kadzik was not one of those people. Let's be clear here. Yes, Ms. Freifeld.
I don't have a formal opening statement, but I did want to clarify, sir, that I did not refuse to come up. We asked clarifications on what exactly you were looking for because it seemed uncertain to us what you asked the State Department about these documents that were produced by the FBI. So I'm happy to be here and try to answer your questions as best I can.
Mr. Herring.
Thank you, Mr. Chairman. I do have a few opening remarks to make.
Yes, you're now recognized.
Thank you, Mr. Chairman. Mr. Cummings.
You can move that microphone just straight up right on there. Yeah, there you go. Thanks.
Better. Thank you, Mr. Chairman, Mr. Cummings, members of the committee, for the opportunity to discuss our production of documents in this highly unusual case with intense public interest. I am Special Agent Jason Herring, the Acting Assistant Director for the FBI's Office of Congressional Affairs. In early July, Director Comey appeared before this committee and answered questions for almost 5 hours to explain the FBI's investigation and conclusions regarding the email matter. At that hearing, and at every opportunity since then, Director Comey has promised that the FBI would be as transparent and forthcoming in this investigation as we could responsibly be. To that end, on August the 16th, the FBI provided to our congressional oversight committees a number of investigative documents to the investigation. It included an investigative summary of the factual information uncovered during the course of our investigation, the relevant FBI interview reports, sometimes known as 302s, and the emails that were determined to contain classified information. We produced these documents to satisfy the committee's immediate oversight interest in the FBI's conduct in this investigation. This was an unprecedented production and one made with extraordinary speed. We did this because we believe it's important for our oversight committees to understand how the FBI reached our conclusion in light of intense public interest in this case. I am not here today to discuss the merits of the investigation, but rather to discuss and answer process-related questions with the production of our investigative case materials to this committee and our other oversight committees. From my conversations with committee staff late last week, I believe I have an understanding of some of the committee's questions and would like to address those issues head-on and up front as best I can. In order to do that, I do need to be in a closed classified setting. I'll reserve the remainder of my opening remarks for when we go to the closed classified setting. Thank you.
Thank you. Ms. Walsh.
Thank you, Mr. Chairman. I have a brief opening statement on behalf of my intelligence community colleagues in the interest of brevity. Mr. Chairman, Ranking Member Cummings, and members of the committee, my name is Deirdre Walsh, and I serve as Director of Legislative Affairs for the Director of National Intelligence, James Clapper. I'm here in response to the committee's request to answer questions about the recent document production by the FBI to Congress related to former Secretary of State Clinton's email. While I understand the Intelligence Community Inspector General, or ICIG as we refer to him, may have interacted with the interagency with regard to these documents, by statute, the ICIG maintains his own interactions with the Congress separate from my office. Accordingly, I cannot speak on behalf of the ICIG. With regard to the documents produced by the FBI and the subject of this hearing, ODNI was not involved with this document production. I will, however, do my best to answer any of the questions that you may have. Additionally, I'm joined by my colleagues from the Central Intelligence Agency, the National Geospatial Intelligence Agency, and the National Security Agency in response to the committee's request. Given the classification of the underlying material, we look forward to discussing sensitive matters in the closed portion of the hearing. Thank you for the opportunity.
Thank you. It's my understanding, Mr. Higgins, Mr. Samuel, and Mr. Soul, that Ms. Walsh's statements reflect the IC. Okay. We'll now recognize myself for the first set of questions. Mr. Herring, what information do you believe that Congress does not have the right to see?
So we believe it's important for oversight committees to understand how the FBI reached our conclusion.
No, wait. I'm asking you a philosophical question here. What does Congress not have the right to see?
So I don't know if I can answer that in a way that, I think there's more to it than a simple answer. I think that each case is sort of specific to its own set of facts. I think Director Comey tried to be as transparent as he could with this committee.
Do you think he could be
other committees as he responsibly can be? So I think when he spoke and he answered questions.
Wait, what is it that I, as a member of Congress, or any member on this Congress, either side of the aisle, what is it that you believe we don't have the right to see? See, this is the way our government works. We get to do oversight. That's why since 1814 this committee has been doing that. There's executive privilege. Let me help you. There's executive privilege. Has the president invoked executive privilege in this case?
No.
The answer is no. Good. That's right. The answer is no. Is there any other situation?
Look, when it comes to classified information and the classification that deals in the executive order, not all the information that we have in our files belongs to us. We defer to other agencies when it comes to access to their classified information.
But you are the ones that put redactions on personal identifiable information, correct?
We did on the personal identifiable information, that's correct.
Where in the Constitution does it say that I can't see that?
Does it address it specifically in the Constitution?
So, can you cite any legal case, any precedent that says that Congress can't look at personal identifiable information?
I cannot cite any legal case.
Are you aware that Congress is exempt from the Privacy Act?
I am.
Does the FBI treat congressional document requests as FOIA requests?
No.
Will the FBI provide Congress all of the 302s?
All of the 302s, we have one set that you've been provided already. The rest of them are coming through the FOIA process.
Wait.
Yep.
We're not, FOIA process? You mean I got to fill out a FOIA request?
You can. Not necessary.
Here's the problem. You handpicked the 302s to give to us. My understanding of discussion with staff, and I appreciate your accessibility with the staff. You've been good, and you're new, and for your first time hearing, this is a tough one, but the reality is you should give us all the 302s.
So let me say this. I think the director made principled decisions about what to say to Congress when he was here and also what to provide to Congress. As far as the
Wait, where do I find that?
Person
Do we just let everybody in government decide that they're based on their own individual principles? That's what see, it's trust but verify is how it works. You don't get to decide what I get to see. I get to see it all. I was elected by some 800,000 people to come to Congress and see classified information. I was elected by my colleagues here to be the chairman of this committee. That's the way our Constitution works. Will the FBI provide to Congress the full file with no redactions of personal identifiable information?
I cannot make that commitment sitting here today.
Then I'm going to issue a subpoena, and I'm going to do it right now. So let's go. I've signed this subpoena. We want all the 302s, and we would like the full file. You can accept service on behalf of the FBI?
Certainly.
You are hereby served. We have a duty and a responsibility. You can cite no precedent, nothing in the Constitution, no legal precedent. You know this is important to us. You now have your subpoena. We would all like to see this information. I've gone past my time, or coming up on going past my time. I'll now recognize the ranking member, Mr. Cummings.
You've been in the job 4 weeks. I can't hear you.
Yes, sir.
And you used to work for one of our distinguished colleagues, Mr. Goodlight, is that right?
Yes, sir.
Republican. So I'm going to, so you're familiar with Congress then?
Yes, sir.
I'm going to save most of my questions for the classified session, but I do want to address the redaction issue briefly. When the FBI produced these materials to Congress, their cover letter stated, and I quote, "The FBI has redacted personally identifiable information as appropriate," end of quote. Chairman Chaffetz publicly announced he wanted the FBI to lift these redactions. He stated, and I quote, "We are going to call on the FBI this week, to give a version where there is non-classified, the unclassified material and the classified material redacted so that could be out there in the public," end of quote. The problem is that there is no legitimate basis for the demand. Director Comey has already provided us with an unprecedented level of transparency into the FBI's investigation and internal decision-making. Now, I want to stop there for a moment. And you said yourself, I think at least twice, that there has been unprecedented discovery here. I mean, what did you mean by that? I don't want to take the words out of your mouth.
No,
correct me if I'm wrong.
I think in this particular case, we don't typically make our case files available. They're sort of internal work product. There's a lot of sensitive information in there. Even the unclassified stuff is sensitive to a great deal. I think that we made a principled decision with redacting the PII only for those individuals who are not already in the public domain. And you sort of ask, why did you do that? Well, from my perspective as an agent, in any investigation, including a high-profile investigation like this one, or any other investigation really, it's critical for us as FBI agents to obtain cooperation from members of the public. As we go out and we talk to members of the public in any case, we need them to be willing to participate in the judicial process. A lot of times people, their initial reaction is, you know what, I don't want to get involved. As an agent, you talk to somebody, you try to protect them as best you can. Sometimes you have to call them as a witness at trial. Sometimes you don't. But witnesses who speak with us need to have confidence that they can talk to the FBI without risk of undue exposure. In this case, we are concerned about lifting the PII redactions for individuals who are not already in the public domain. It might have a chilling effect on the willingness of other members of the public in the future to cooperate with us, particularly in an investigation like this. And so I think that Director Comey's, or what we as an agency tried to do was to satisfy the needs of the Oversight Committee by letting you all see exactly what we did in our investigation, the investigative steps we took, and how we came to that conclusion. I think he did it in the form of taking questions for more than 4 hours, but also making our files available, and that's not something that we typically do. We did make a principled decision as far as how are we going to affect this, how are we going to give that visibility to our oversight committees. We made a very thoughtful, I think, response in redacting only limited PII for the people that are not already in the public. And really, from my perspective as an agent, this is Jason talking.
How long have you been an agent?
17 years.
Okay.
And so, from my perspective as an agent, I think we have to protect the integrity of our investigations. And I don't want there to be a chilling effect, or I wouldn't want there to be a chilling effect for other people cooperating in similar cases like this going forward.
Well, one of the things that I asked Director Comey about was this whole process when you've got the Congress getting more and more information from the FBI and whether it would have a chilling effect. Do we place ourselves in a position where if the Congress does not like a decision made by the agency, then dig, I mean, how much, how often will that be happening? In other words, so that chilling effect, and then I wonder, will other people, if the decision, somebody in Congress doesn't like the decision, do we set more and more precedents so that people can come in behind? And Director Comey said he had an all-star group of agents, and they had a unanimous decision. And I just, but you were talking about the chilling effect. So do you think that? But first of all, who made the decision with regard to the redactions? Since that's what we're supposed to be here about. I mean, I'm just curious who makes those decisions.
I think that was made at the highest levels in the Bureau.
And does that mean Director Comey?
Absolutely.
All right.
If I could say just sort of.
Please do. I thought I had some time, but go ahead.
I mean, I do think it's reasonable to think there would be a chilling effect. This is a very public case. Everybody out there is watching it. And we start lifting personally identifiable information. I think that potentially could have some impact going forward. I do think, though, that We're not trying to play hide the ball with Congress. We want Congress to be able to do its job, this particular oversight committee do its job, and to understand really, what we did in the investigation, how we came to that conclusion, and we did that in part by, releasing the investigative summary and the 302s.
Thank you very much.
Thank you.
Some of the 302s. And when you don't show up at a meeting that we request behind closed doors, kind of lose that opportunity.
If I could,
Now we're going to recognize the gentleman from South Carolina, Mr. Gowdy.
Agent Herring, did the FBI interview the sender of all emails that contain classified information?
I don't know the answer to that question, only because I'm a Ledge Affairs guy. I was on the investigative team.
Can you find out? You would agree with me it'd be important. I mean, you'd want to interview the person who sent the classified information, right?
Certainly.
Because the recipient thought the C was just the third letter in the alphabet. You might be curious whether or not the sender also was clueless in the way he or she viewed classified information, would you not?
That would be a logical investigative step.
Can you find out whether or not you interviewed the sender of all emails that contain classified information?
Certainly.
Do you know if the sender of any of the classified emails knew that the information was classified at the time?
I don't personally know that. I wasn't part of the investigative team. I'm sure that.
Can you find out?
Certainly.
Can you find out for me?
Yes, sir.
There are folks wondering how information gets from a classified source into an email. Did your investigation shed any light on how classified information could get from a classified system into an unclassified email to even be sent? I'm not even talking about the receiving of it. I'm talking about the sending of it.
I'm sure they did look at that. That would be sort of a logical question you would ask as an investigator in a case like this.
That's what I thought.
But in my legislative sort of affairs capacity, I just don't have that kind of visibility.
Well, don't sell yourself short. You used to be an agent, right? Still an agent, right?
Well,
so you know what you're doing. Did the FBI grant immunity to anyone during the course of its investigation?
For immunity questions, I'd have to defer to the Department of Justice for that. It wouldn't be an agent who would grant that kind of thing.
Did the Bureau recommend the granting of immunity?
I do not know.
Do you know whether the Department of Justice granted immunity to any witnesses?
I know I saw some articles last week, but that's the extent of
Well, surely you got better sources than the media for that, don't you? You can ask the guy sitting 2 people down from you.
I would have to defer to the Department of Justice, sir.
Do you know whether any witnesses asserted any privileges while they were being interviewed?
I don't know.
But the Bureau would know that, right? Because they would have asserted the privilege while you were in there.
I'm sorry?
The Bureau would know that, right? Because that privilege would have been asserted perhaps while you were in there conducting the interview.
What kind of privilege are you talking about, like attorney-client privilege?
Oh, there are a bunch of privileges. There's priest-penitent. I'm guessing that one didn't come up. There's doctor-patient. I'm guessing that one didn't come up. There's the Fifth Amendment privilege against incrimination. That one might have come up. Attorney-client privilege, again, there have been media reports that one came up.
Sir, I just don't know the answer to those questions.
Have you ever had the attorney-client privilege come up during any of your investigations?
Certainly.
Who does the privilege belong to?
The client?
So the client can waive it, right?
Can.
You understand why Congress might want to know whether or not the attorney-client privilege was waived and who the client was?
I can certainly imagine.
Yeah, me too. That's why we want to see the file, Agent. I mean, you say it's unprecedented. Mr. Cummings used to be a criminal defense attorney. He got to see all your 302s. Ken Buck used to be an assistant United States attorney. He got to see all your 302s. Probation officers get to see all your 302s. Why can't Congress?
Sir, I think we have tried to provide the information in a way that is understandable. I think the investigative summary tells kind of the story, and I do think that the 302s that we provided are the important ones.
Well, let me ask you this. If those summaries were all anyone ever needed, why don't you just introduce those in trial? Why actually call the witness?
Well, certainly we actually trying to make your life a little bit easier in the light of the
But see, I don't want my life being made easier. I don't want that. I want to know what was said in the 302s. Because the 302 is itself a summary of an interview, right? It's not a verbatim transcript.
That's correct.
So you have given me the summary of an interview. And I'm not asking for a verbatim transcript because you don't have one.
Sure.
I'm just asking for the 302. So I don't have to read your summary. I may read the 302 differently from the way you read it. So why not?
So I think we've given you the relevant ones as we've
relevant according to whom? I am telling you, I don't think you've given me all the relevant 302s.
Well, the remainder of the 302s will come out through the FOIA process.
But since when did Congress have to go through FOIA
Correct.
to obtain 302s from an investigation that's not even resulting in any prosecutions that your boss has already said is over? Since when did we have to go through FOIA?
So I think that the 302s we have provided, I think that we made a principled decision about what to provide. It was certainly made at the highest levels of my agency.
All right, I'm out of time. That's what that knocking sounds. I'm just going to say with all due respect, you don't get to decide what we think is relevant. And I do say that respectfully. The defense attorneys get it all. I think Congress ought to get it all.
Thank the gentleman. Now recognize the gentlewoman from New York, Ms. Maloney, for 5 minutes.
Well, thank you, Mr. Chairman, and I'm going to reserve my questions to the closed session, but I would like to clear up some misconceptions. I would say that the campaign season is upon us, and the accusations and the charges and the attacks are almost out of control. I just spent, I won't get into it, but anyway, for several weeks, the chairman has been appearing on national television saying that the reason that he cannot see these emails is because the FBI produced to Congress is because they are such a highly sensitive, classified, high level. And for example, he stated that these materials were, and I would like to put his quote in the record, so secure and sensitive that even I, as the chairman of the Oversight Committee, did not have the proper clearance to see it. But in fact, as I understand it, Mr. Herring, Chairman Chaffetz has not been able to view these documents. The reason he hasn't been able to see them is because the Republican chairman of the Intelligence Committee has not allowed him to do so. The documents were produced and given to the Intelligence Committee, and the Intelligence Committee has a process by which they release the documents to people, and he has the same clearance as any other member of Congress who's not on the Intelligence Committee. And so the reason he hasn't been able to get them is because his own party's leadership has not voted to give him this clearance. Now, as I understand it, the FBI produced a small subset of these emails only to the Intelligence Committee. And according to House rules, the Intelligence Committee has the jurisdiction over certain agencies, and these agencies report to the Intelligence Committee. So it has a process in place. And for any member who's not on the Intelligence Committee to see these documents, and they need to send a letter to the committee, which Chairman Chaffetz did, and I have his letter from September 2nd, and I request unanimous consent to place it into the record.
Without objections to order.
Okay, so he sent this letter saying he'd like to see them and ask permission, and the Intelligence Committee needs to take a vote. Now, as I understand it, the chairman of the committee has not scheduled the vote that would allow the chairman to see these documents. Now, I just feel that a lot of this is just pure, plain politics as usual, stirring up a hornet's nest over documents he can't see, which are being withheld by his own party. And it seems that they do not want to open up the Intelligence Committee's jurisdiction at this point. I don't know why they're not taking the vote that would allow him to see these documents. But what our committee is engaged in is nothing, in my opinion, nothing more than a partisan election bashing exercise stating that these emails can't be seen when they can be seen if his own party votes to let him see it. So I just say that it's politics as usual, and I'm disturbed about it. There is a problem with the classification system. We all saw that in the last hearing. Let's work together to correct it. But this whole charade is just that, a charade. These documents are not being withheld from the chairman because of anything any of these witnesses have done. They are being withheld by the Republican chairman of the Intelligence Committee. So I respectfully suggest to my chairman that we bring in the chairman of the Intelligence Committee and ask him why he doesn't have a vote and release the documents to you. It is not the FBI, but the House Select Committee on Intelligence who's withholding these documents. So
Will the gentlewoman yield?
I most certainly will.
Any one of the 4 people from the intelligence community here can help answer this. Have you made redactions on personal identifiable information to the Intel Committee? Mr. Higgins, how about you?
No, we have not.
There's no redactions at the... Ms. Walsh?
Not to my knowledge.
Mr. Samuel?
No, Mr. Chairman, not to my knowledge.
Mr. Sewell?
No, Mr. Chairman, not to my knowledge.
Can you release these emails into the public? And if so, what would happen? Mr. Higgins, what happens if we release these emails that are on Hillary Clinton's unsecured server? What happens?
Mr. Chairman, I can confirm that CIA participated in a classification review process, and I'd be happy to talk about that process in closed session. Needless to say, some of the materials do include classified information that we do not believe is appropriate for public release.
And are some of these materials include sources and methods?
Mr. Chairman, I'd prefer to discuss any further matters relating to classification in closed session.
Gentlewoman's time has expired, but thank you so much for yielding to me.
But reclaiming my time, I get to close in my time. You took all my time. I thought the chairman could have, I think the chairman can have all the time he wants. I'd just like to conclude by saying, and I just ask for a second, just a second, what our committee is engaged in is nothing but a partisan attack on Secretary Clinton with an effort to harm or undermine her presidential campaign. That's all it is. Get the chairman of the Intelligence Committee to release the documents to you. No one is withholding it. The Intelligence Committee has jurisdiction over agencies, including the FBI. They release their information. They have a process. You have appealed to that process. Let's wait for that process. Ask him why he's not taking a vote to give you access to these documents. You're making it look like there's some conspiracy or some terrible thing happening when it's really nothing but a partisan attack on Secretary Clinton.
I thank the gentlewoman, and I guess